Now we have a chance to look at a criminal procedure hypothetical that tests a number of issues that are very common on bar exams and law school exams all over the country. As always, we'll start by taking a look at the call of the question. 1. How should the federal court rule on Dan's motion to exclude the heroin found on his person from evidence at the federal trial? Discuss. Obviously, it's a Fourth Amendment question. We have to examine the defendant's standing to raise the Fourth Amendment, and then we have to examine, presumably, a warrantless search. 2. How should the state court rule on Dan's motion to exclude the heroin found in his car from evidence at the state trial? Discuss. Well, this is another clear Fourth Amendment issue. We'll have to carefully examine the facts. Again, we'll have to determine whether or not the defendant has standing to object to any of the law enforcement's activity, and we'll have to reach a conclusion based on applying the law to those facts. Then question 3, how should the state court rule on Dan's claim that he is entitled to have bail fixed or be released pending trial on the state charge? Discuss. Well, this is probably going to turn out to be a short answer question, and we know that the Eighth Amendment hasn't been applied to the states, so there's no federal right to bail. State constitutions typically have got a bail provision in them, but that doesn't mean that this guy necessarily has to be let out pending trial. We'll take a look at the facts and we'll see what else there is to discuss. So now, go to the top of the question, and we'll see in the first couple of lines that this is a border search. We've got a federal customs inspector, Fred. He sees suspicious activity at the border, and he decides to take further action and to engage in a fairly elaborate search at the border. Is there anything in paragraph 1 that suggests that Fred has done anything that runs afoul of the Constitution? Answer, no. We have a very low expectation of privacy at a border. Here, the customs inspector has seen suspicious activity, which, incidentally, I think would give rise to full probable cause if it occurred somewhere other than at the border. But indisputably at the border, this customs inspector has got a right and arguably an obligation under his job duties to investigate further. And the result of paragraph 1 is we found the inspector has found an awful lot of drugs on the other guy, Anon. So, in paragraph 2, we've got a body cavity search that is ordered by Fred and performed on Dan. And with regard to body cavity searches, our basic question is there anything about the search that shocks the conscience? It's really more from the Fifth Amendment than from the Fourth Amendment as we get into the details. And as we see from this fact pattern, the customs agent gets a doctor to perform the search, and that's certainly going to be considered constitutionally adequate. We could imagine different facts that would reach a different result. Suppose we had a female suspect who is roughly searched by untrained male customs inspectors or border guards. The closer it looks to a gang rape, the less likely the evidence is going to be admitted. But here, we've got a physician conducting a body cavity search, which is absolutely reasonable under the circumstances, and not only is it reasonable, but it results in highly probative evidence against this defendant. So now we've got all we need to know to answer the first call of the question: how should the federal court rule on Dan's motion to exclude the evidence found on his person? The federal court ought to deny that motion, because there's nothing about the search and seizure of these drugs from this defendant's body cavity that would justify exclusion. Now, let's move on. In paragraph 3, we've got all the facts we need about the car. And this Fourth Amendment argument is much stronger. Take a look at what happened. Fred notifies state law enforcement officials about the arrest, and Olson, a state agent, locates Dan's car. But look carefully in the second line of this paragraph. Dan's car is lawfully parked on a street in the United States near the border crossing. And this state official impounds the car and searches it and finds more drugs. And that causes the defendant to be subject to state charges. Well, that's a search that's not going to survive Fourth Amendment scrutiny. Why? The car was lawfully parked, and there's nothing in the facts that suggests that this officer couldn't have gone and got a warrant. There's no judge in the country that wouldn't have issued a warrant to search this car. But since it's lawfully parked, the police don't have reason to just seize the car without a warrant. If there's some concern about the spoliation of evidence or some other tampering that might take place, the police should put an officer at the vehicle, send another to get the warrant, and then come back and impound and search the vehicle. But the police acted too hastily, and they trod on the Fourth Amendment, and the result is going to be favorable to the defendant. Then in the last paragraph of the fact pattern, we've got the facts that give rise to the third call of the question. Here the defendant is arguing that he's got a right to having bail fixed, or, since he's broke anyway, the right to be released on his own recognizance. And we've got a state preventive detention statute mentioned where there is a defendant posing too great a threat to society. Well, we can just leave that guy locked up for trial. Well, as we think about that, again, I don't think there's any disputing the fact that the drug trade is unhealthy for children and other living things. The drug trade's a violent business, and drugs themselves certainly cause a reasonable amount of social harm. But is this defendant the sort of person that we wish to preventively detain? It seems to me much more likely that a preventive detention statute would have a better application to someone who's engaged in violent crime. Someone who is, say, an enforcer for a drug gang, or a collector for a gambling syndicate. Those people are probably a little bit more immediately dangerous to society than someone who is charged with importing or trying to distribute drugs. Still, the fact that he's indigent doesn't automatically entitle him to have an own recognizance release, only to have reasonable bail, and that's not even a federal right. So, turn the page. Let's have a look at an outline of issues and briefly consider these ideas a little bit more thoroughly before we wrap it up and move on to the next hypothetical. This hypothetical really is quite well constructed, and in fact, in some respects, it's sort of generic. These issues arise ritualistically on just about every multi-state bar exam. You're likely to get one or two questions that will echo things you've seen in this question. It's extremely worth studying. Also, state bar exam questions and multi-state essay exam questions with elements strikingly similar to these have appeared routinely over the last several decades. So, take a look at the outline of issues. In our outline to call of the question 1, I indicate that the federal court should deny Dan's motion to exclude the heroin on his person. We begin by considering the standing of this guy to raise these concerns. Yes, he was the target of the search, but he doesn't have an expectation of privacy at the border. And plus, the facts surrounding his being singled out for this kind of treatment show that law enforcement is acting absolutely reasonably and living up to their statutory duties as law enforcement officers. So the initial stop is legitimate, and then the further body cavity search also is legitimate. The facts that the Customs guard uses to justify ordering the search are absolutely reasonable, and the search itself doesn't shock the conscience because it was performed by a doctor. Presumably it was safe and private. So the bottom line is the federal court should deny this first motion, but the good news for the defendant is the small quantity of heroin found on his person is going to subject him to an awful lot less criminal liability than all of the heroin in the car. And so we turn to the state court motion to exclude the heroin found in the car. The Fourth Amendment has been applied to the states via the 14th Amendment, and here we've got a plaintiff who does have a reasonable expectation of privacy in his car, and the fact that he was arrested does not give law enforcement the license to just seize this property. Yes, I agree that the officers have probable cause, but they've got probable cause to get a warrant. This is not a moving automobile for purposes of the automobile exception to the warrant requirement. So we see that the cop had no warrant and had probable cause, but didn't have probable cause to act without a warrant. So the car is not a moving auto, and the car was not lawfully impounded. Suppose the police had come back to find that this car had been parked too long, and that the meter had expired, or that a parking attendant had marked the car for having been present for more than 72 hours or however long a car is allowed to be parked without being moved. Well, if the car hadn't been lawfully parked, it lawfully could have been impounded, and an ordinary impound search would have turned up these drugs, and they'd be admissible against this defendant. But because law enforcement got into too much of a hurry, because law enforcement skipped the necessary step of obtaining a warrant, all of the heroin found in this defendant's vehicle is going to be subject to exclusion, and that is great news for this defendant because serious drug charges will now evaporate, and he'll only be facing the federal charges. Now, that leaves us with the last call of the question about bail. Now, my take on the issue is probably this guy is entitled to reasonable bail. If he can't post bail, then he's going to be stuck in jail until trial. But absent his ability to pay bail, he is not constitutionally entitled to an own recognizance release, and he's also not entitled to claim the federal Constitution as a right to bail. He's only allowed to use the state Constitution. We've also got this preventive detention statute to consider, and as I indicated initially, it seems likely that the preventive detention statute shouldn't be applied to this defendant because he's not in the class of suspects that it is designed to target. But even so, probably he is entitled to bail under a state constitution, and probably he's not going to be able to post it, which means he's going to sit in jail until a trial. But as for a state trial on heroin possession, his Fourth Amendment claim is likely to result in an acquittal based on a lack of evidence. So that wraps up a consideration of a tricky and fairly complicated question presenting fairly simple issues that aren't that difficult to resolve.